Happy Sunday, everyone, and welcome to Our Issues Birmingham. Today's guest is Judge Michael Streety, and I just learned he has no middle name. I don't think I've ever met a person with that.
Michael Streety.
Well, they just couldn't decide.
I've
got a daughter.
I questioned my mother about it. I just accepted it the way it was.
That's pretty good. Well, we've known each other way long. I take pride in announcing to the universe that I was one of his professors while he was in law school. And unbeknownst to me at that time, he was also working as a sheriff's deputy at that point.
At that time, a sheriff's deputy and later a probation and parole officer.
So tell the audience how you got to where you are now and what it took to get there.
Well, sometimes I say, honestly, I don't know, but the track was I initially wanted to be an educator. As a matter of fact, I majored in English in college and a minor in political science. So I thought I wanted to be an educator. A funny story is I was working as a customer service rep at a paging company, and a deputy came in and I saw his badge. I said, "Hey, that's interesting. What do you do?" And he said, "I'm an investigator." And he intrigued me about law enforcement. And he told me to call him. And I called him, and he convinced me at that time to try and be a law enforcement officer. And from there, in 1996, I became a deputy sheriff with the Jefferson County Sheriff's Department.
That would have been in Mike Hale's era or Mel Bailey?
It was Mel Bailey initially. And then Jim Woodard.
Oh, I forgot about him.
Mm-hmm.
He got in trouble.
And then Mike Hale.
Mm-hmm.
That's right.
So you've served under several sheriffs.
Yes, indeed. And so while working with the Sheriff's Department...
Now, when you say working, you're on patrol doing the things?
Well, not yet, because when you initially started the Sheriff's Department, you worked as a deputy in the jail.
Yes.
So I had not...
That's sort of the penalty box. That's right. Where you start.
I had not transitioned to patrol yet. And so I had a buddy, an older gentleman who was in law school. And I told him that I was thinking about going back to school to, get my teacher's certification. And he said, "Really?" He said, "You ought to think about law school." I said, "That is ridiculous."
He was right.
But he kept talking to me and he convinced me, and I looked into it, and I started law school while I was with the Sheriff's Department, going to school at the Birmingham School of Law at night.
And that was right around 2000, I'm thinking.
That was.
Because that's when I was teaching there.
That's right. Exactly. I finished law school in 2002. Okay. But, while I was a deputy sheriff and in law school, I wanted some courtroom experience because necessarily I was assigned to the jail. So I didn't get much courtroom experience. So I said, I need to do something different. And so I left the Sheriff's Department and went to the Board of Pardons and Paroles and became a probation and parole officer.
Oh, I remember when you were a probation officer.
And I was directly assigned to a courtroom at that time. And
do you remember whose courtroom you were?
It was Judge Cahill's courtroom.
Oh, goodness.
That's
that
right,
was
Judge
an
Cahill.
Interesting life experience.
And Steve Mahon. I don't know if you know Steve.
I know Steve. I know everybody.
And he was a prosecutor.
I'm old, Judge. You know how old I am. These are scars, not wrinkles.
I'll say you're seasoned. You've been around a while.
I have been around a while. I'm weary. So from your experience, what's happening while all this is going on, unbeknownst to you, you're gaining a worldwide view of the criminal justice system from lots of different angles. So now you're assigned as essentially a bailiff and a probation officer with Judge Cahill.
That's right.
And you're attending law school at night.
That's exactly
which
right.
You've got to admire the people that are at Birmingham School of Law because they work all day and go to school at night. Mm-hmm. Ultimately, you passed the bar.
That's right.
And you went to work for what, the district attorney's office?
I went to work for the district attorney's office, and I was a prosecutor for 13 and a half years.
So that's another viewpoint.
Right. And I can tell you, at that time, I did not realize it, but it has been so valuable for me as a judge in the role I'm in now.
Well, the only thing you missed was the criminal defense side, because I was a judge for a little while too, and 15 years with the city of Vestavia. And it does give you a different perspective on things.
It does.
So do you find it hard sometimes? Your job as a judge is to sit in the middle and to stay balanced and to remain consistent. At least that was my mantra.
Sure.
And when you don't know what to do, continue the case. That's what Judge Hard taught me.
So, I have to be honest, when I initially started as a judge, I had to make a deliberate effort to make sure I did not go back into what I knew as far as law enforcement.
Yeah.
And to make sure I honored that position to be sort of a moderator, to be fair and impartial, to make sure I listened to both sides. You have to, in my opinion, because I was a law enforcement officer, a probation officer, and a prosecutor for so many years, I had to make a deliberate effort to make sure that I understood my role as a judge and was true to that.
And you've apparently succeeded at that. And
Thank you.
Subsequent to, you ran for circuit judge in what year?
2016.
So we are now 9 years
Yes.
Down the road. And you are circuit judge, and then how do you become presiding judge?
Well, in Jefferson County, you have several different divisions, and we're unique in the sense that our judges are divided into divisions. And so from there, the presiding judge nominates you to be a divisional head based on the voting of the other circuit judges. And
you got nominated and voted to be the presiding criminal court judge.
Voted on by the other circuit judges and appointed by the presiding judge.
Which is Judge French.
Judge Elizabeth French.
All right. We're going to pick up your career when we come back from break. So
Excellent.
Don't leave me.
Thank you.
This is Our Issues Birmingham. Don't go away. Lots more to come. Welcome back to Our Issues Birmingham. I'm talking to Judge Michael Streety, no middle name. And he has just described for us a very long, tenacious, persistent track of his professionalism. And he's still a very young man. He may not realize it, but I wish I would be around 30 years from now and you would be in this chair and I would be somewhere else in a small crypt, returned to our maker, I hope. So the criminal justice system, I've had the luxury of watching it evolve. And there was a time when it was strictly adversarial. And, my side of the bench is pulling one way, prosecutors pulling another way. Sometimes the parties come to an agreement, which you are the one who signs off on. You don't have to, but you generally do, and most judges generally do, because as Judge Owens said to me, her client is her docket. Absolutely. I thought that was very well put.
Absolutely.
So people get frustrated with the delay that it takes to get from A to B. And when I say that, I'm speaking primarily of people who have been harmed. Because from my perspective, and now I'm excluding the people that remain in jail without bond or bonds they can't make, because we need to really get to them first.
Sure.
Because believe it or not, there is still a presumption of innocence in this country.
Absolutely.
And you're not convicted unless 12 people say you are. And when that happens, it changes things. Can you shed some, I've talked too much already, can you shed some light on overview of why it is that it moves as slow as it does to the public's, from the public's perspective?
Sure.
And I recognize that Governor Ivey just put in play some new rule about retired judges coming back to speed things along.
Sure. Well, I think the phrase that everyone should keep in mind is due process of law. That's
It's in the
very
Declaration
important.
of
It's
Independence,
just very
actually.
important, and like you said a moment ago, when people are charged with offenses, they are really just allegations. Someone has accused a person of something, and it's just an allegation. So the process then has to start. And sometimes the process is not as smooth as we think it should be or as efficient. And it depends on the case itself. And for an example, a capital murder case. That case has so many different facets, things that have to happen just to make sure that the final outcome is just. It starts in district court. It'll eventually end up in circuit court, but there's a whole process in district court that it has to go through. And quite frankly, the volume of cases that we see here in Jefferson County, as far as the serious cases, sometimes slows the process. And it has nothing really to do with the court system. Now, I will say that during COVID, of course, things got backed up. But, we've managed to sort of rebound somewhat. But it's just the way the process goes. There are so many issues that come up in capital cases, like mitigation.
Yeah.
And there's so few mitigation experts in the state of Alabama. There's really a shortage. And if you don't have a mitigation expert in those cases, that case cannot move forward as a capital case where the ultimate punishment is death.
So those of you that are looking for a new career, think in terms of becoming a mitigation specialist, which I think you have to have some psychology.
You have to have some counseling in mitigation. Training in mitigation, about not necessarily a psychology degree or anything like that.
Well, you made a comment about due process, and people give lip service to the presumption of innocence, but it's alive and well. They may nod that they believe in it, but a lot of cynical old-time defense lawyers like me don't know that they really do. But I do think juries try their darndest to do what's right. I mean, when they get back there in that room, they got no guardrails.
Mhm.
And I feel that the system, more often than not, works.
Sure.
One thing I've noticed Jefferson County has started doing to try to speed up the process, and when I say started doing, I'm talking about post-COVID.
Mhm.
I think it's post-COVID. Assign the case right out of the box to the circuit judge that's going to hear it.
Okay. Very valid.
That speeded up.
That's
because that eliminates that district court. Well, you get familiarity with the case for starters
Sure.
as a judge.
Mm-hmm. Initially, when the case comes into the system, there is a district court judge assigned to it and a circuit court judge. Now, of course, the district court process has to play out. But when the case is bound over to the grand jury or waived to the grand jury after 14 days, then the circuit court judge's jurisdiction kicks in. And while the case is pending grand jury, several things still can happen on the case that will make the process more efficient. And lawyers file motions when the cases are on grand jury that the circuit court judge can then attend to. Before that, there was no particular circuit court
It just
judge
went
assigned.
into a hole,
Right.
a vacuum.
Right.
I've noticed that nowadays all cases are immediately assigned to a circuit judge
Yes.
before you make your initial appearance even.
And it's very helpful, quite frankly, because now
Yeah.
the lawyers know exactly who to go to
Right.
for those outstanding motions.
Well, not just motions, your strategy, to plea or not to plea, to try or not to try. Is it triable? It may
Right.
not be triable,
Right.
even though there is a presumption of innocence. It just might not have the right facts. So there are a lot of moving parts that I don't think folks understand in their
agree.
entirety. If you had to pin a problem that you'd like to see cured, and you've got about 20 seconds to answer this question, what would it be?
I think you mentioned something about the lawyers having understanding that the process is adversarial, but I just don't think the lawyers communicate with each other enough.
No, they don't. They want to
If
email
I
it.
could cure a problem, that would be it right away.
I wish people would talk to each other. We're going to take a short break, come back and finish up with Judge Streety. I'm Tommy Spina. This is Our Issues Birmingham. We'll be right back. Welcome back to Our Issues Birmingham. There's a word that gets thrown around in Alabama and probably around the country called, it's a law named after a young lady who was murdered, named Anaya Blanchard.
Sure.
And it's called Anaya's Law. And for the first time in our history, we talk about due process. We have certain offenses now under Anaya's Law that automatically move into a no bond dynamic from Jump Street, whereas before that law, anybody was entitled to a bond unless you were charged with a capital offense.
Sure.
So, as simply as you can put it, explain to our viewing audience what Anaya's Law is, how it works, what protections are in it for the benefit of the person charged and also for the complaining witness family.
Sure, sure. Well, Anaya's Law deals with really violent offenses. Those offenses like robbery, rape, kidnapping, and murder. The law was passed where automatically the bond is
and
set.
Domestic violence.
And domestic violence in the first degree. Automatically, the bonds in those cases are set at no bond when the person is charged. However, within a few days, the judge has to have a hearing called a pre-trial detention hearing. And at that hearing, the state has to put on evidence to show that this person is, by clear and convincing evidence, there's no reasonable theory to suggest that the person would not be of harm to others and the victim in the case, or that the person will show up for court.
So they have to show that he's either a risk of flight or a danger to the community.
A danger to the community or to a person in particular, and that is the victim of that particular case.
And there's a hearing.
And there's a hearing that the judge presides over.
It somewhat mimics federal law. In some cases in federal court, there's an automatic detention.
Your probable cause has to be shown at the hearing, and the state of Alabama has to show by clear and convincing evidence that there's no reasonable, and the wording, there's no reasonable rationale theory to think that the person, any bond conditions.
My words are, there are no conditions or combinations of conditions that could ensure
combination of conditions
like electronic monitoring and GPS and all kinds of
that
other
would protect
devices.
The public or a particular person from harm.
Well, would you agree with me that because our legislative body, who doesn't always deliver us paradigms of clarity when they enact legislation, that they miss the boat sometimes, and as a consequence of, in this instance, Anaya's Law, sometimes there are collateral consequences that weren't intended.
I agree with that.
But that's the job of the detention hearing, or the purpose of
the pretrial detention hearing has to happen quickly. And so the person doesn't, just stay in jail without this hearing. The state can request a continuance, and the defense can request a continuance as well.
Right.
However, it has to happen right away, quite frankly. And most judges that I know make sure that the hearing takes place as soon as possible, because we have 48-hour hearings. And typically at that hearing, the judge will immediately set a pretrial detention hearing. So within 48 hours, the hearing is set. And typically I'll have the hearing within 24 to 48 hours after the initial 48-hour period when the person is arrested.
So you said a couple of things I'm sure nobody understands. Mm-hmm. A person gets arrested. you use the word 48-hour hearing. There's also a 72-hour hearing.
Yeah.
Explain that.
So the difference between a 48-hour hearing and a 72-hour hearing, if a person is arrested for a felony offense and there is not a bond, he has to have a hearing within he's not released. He's not made bond. He has to have a hearing.
He doesn't even have a bond.
He doesn't have a bond. And sometimes he has a bond, but he can't make it. Then the judge has to have a hearing within 48 hours of the person being arrested. Now, if a person is arrested on an outstanding warrant, then the judge, when the person is arrested, has to have a hearing within 72 hours. You have a situation, 48-hour hearings, where there is not a warrant, the person is arrested on probable cause. However, when there is a warrant issued, the person is arrested, the hearing has to happen within 72 hours.
So what he's explaining, the difference there is some people have outstanding warrants that are just stuck in a filing cabinet somewhere and in the system, but the person has never been served with the warrant and therefore he's never been, quote, arrested. As opposed to the 48-hour hearing is like caught in the act, arrested on the spot.
That's right. A person is caught in a stolen vehicle.
Yeah.
He's incarcerated. The bond is said. He's not made the bond and he's still in jail. He has to have a hearing within 48 hours.
Well, we could talk all day about all of these things. We don't have all day. But you used another expression I'm sure people are not familiar with. He used the expression clear and convincing evidence. So we have standards of proof in our criminal justice system, the lowest of which is probable cause, which doesn't take much, and the highest of which is beyond a reasonable doubt, which everybody's familiar with from toe, is clear and convincing. And right below that is a civil kind of burden of proof, standard of preponderance. And that's just where the scales tip slightly in favor of one side or the other. So I would say clear and convincing is a pretty high standard, although it doesn't rise to the level of beyond a reasonable doubt.
Well, probable cause still has to be shown, but that clear and convincing standard comes in when you're showing that there can't be any combination of conditions that will protect the public. That's where that standard comes in.
It's a tough spot you're in, and I don't envy you, but I'm damn glad you're there. You do a great job.
Well, thank you.
And I appreciate you coming on the show and shedding some light on the criminal justice.
I call you professor for a reason, right?
Well, and I'm grateful for it, and I appreciate you, and I appreciate you coming here today.
Well, thank you. I appreciate you having me.
I'll see you soon.
Right.
And I'll see you next Sunday. This is Our Issues Birmingham. Have a nice day.